This is AdTech God, and this is a word from our sponsors. Samba TV is a global leader in AI-driven media intelligence powered by first-party data from millions of opted-in connected televisions and billions of web signals across the globe. Its independent cross-platform measurement provides advertisers and media companies with a unified view of the entire consumer journey. Leveraging real-time insights and audience optimizations, Samba TV enables marketers to reach and engage audiences with efficiency and effectiveness across any platform and every screen. Visit samba.com to find out more. Again, go to samba.com to find out more.
Hey, this is Ari with Marketecture. And unless you've been living under a rock, you've probably heard that Marketecture Live is coming up October 27th in New York City. The last Marketecture Live was sold out, and this one will surely be as well, with speakers like Mark Grether of PayPal, Eric Seufert of Mobile Dev Memo, and Jenny Wall from VideoAmp. Plus, I'll be recording my podcast live with the one and only Antonio Garcia Martinez, author of Chaos Monkeys, and now part of the team building at Coinbase. It's a stacked agenda, and we hope to see you there. Go to marketecturelive.com and grab your ticket while they're still available. That's marketecturelive.com.
Welcome to the Monopoly Report. The Monopoly Report is dedicated to chronicling and analyzing the impact of antitrust and other regulations on the global advertising economy. If you are new to the Monopoly Report, you can subscribe to our weekly newsletter at monopoly-report.com, and you can check out all of the Monopoly Report podcasts at monopolyreportpod.com. I'm Alan Chapell. This week, my guest is Daniel Hanley, Senior Legal Analyst at the Open Markets Institute. Daniel's research focuses on antitrust law, political economy, and how the law structures power in our society. I've been following Daniel's work on Twitter and LinkedIn for some time and know that he has some strong views on Judge Mehta's recent remedies decision in the Google Search Antitrust case. Before we jump in, I wanted to highlight that I did an emergency pod with Ari Papero on the Marketecture pod. And that podcast went into more detail into the business implications of Judge Mehta's recent decision. So this discussion, the one with Daniel, is going to lean more heavily into the legal implications. So let's get to it. Hey, Daniel, thanks for coming on the pod. How are you?
Doing well. How about yourself?
I'm doing great. It has been an absolutely insane week, even by regulatory ad tech lawyer standards, because I know we're going to talk about the Google decision, but heck, we've got a definition of personal data coming from the EU Court of Justice. You've got a fine against Google, which has a whole bunch of underpinnings coming from the EU Commission. You've got a lawsuit that was just settled against Google. You know, I'm starting to get to think that there's a common connection to all this.
I wonder what it could be. Maybe a single company that's has its tentacles and everything.
Yeah, it turns out that might just be a problem. Who knew?
Yes. Yeah. Actually, it's been held a problem for a number of people.
Okay, so here we're talking about Judge Mehta's decision on September 2nd in the Google Search Remedies case. And so let me set the table. In August of 2024, Judge Mehta determined that Google had illegally maintained its search dominance through billions of dollars in exclusive default placement agreements. And each of the parties, the DOJ, the blue states, and as well as Google, had proposed remedies to address Google's monopoly. So Google proposed a set of remedies that struck many of us as milquetoast, to put it very kindly. And then Judge Mehta issued a decision that, for the most part, seemed to follow Google's lead. So here's my question. What in the world happened here?
Yeah, that's probably the $1 million question here. But I think it might be important to take a step back a minute, just because I feel like what really frames the discussion is, or I guess with any, sort of analytical analysis, right, is there's a timeless saying, compared to what? So like, where are we coming from? So like, you come out of the gate in 2024 with an opinion that line that was literally plastered all over every news outlet. Google is a monopolist, right? Like it was short, succinct, punchy. It had all the elements of like, wow, like we're going to hold one of the world's largest companies accountable, and they violated democratically determined law. And then the liability opinion, again, as you described, was released last year, just goes into a whole slew of descriptions about the financial firepower that Google used. Google used its treasure trove of capital reserves to basically bribe its way into shutting out competition, whether it's on Apple's iOS ecosystem to be the default, through Mozilla's browser, through Android manufacturers. And it's basically Google pushing the competition out of its way and basically controlling one of the most essential channels of how people get information, how people get to that. They basically created a one-way tunnel from consumer platform to Google search. And again, the liability opinion read very strong. And as is typical case, we get to the remedies opinion, and it's, as you described, like, what happened? Like, yeah, I think that it was shocking even for me. And I think even based on some of the news I've read, even for more mainstream people, they were kind of taken aback, be like, wow, like, not only are there some inconsistencies here, there's, misstatements of the law. There's also, again, even by more moderate scholars, they were like, wow, this seems much more reserved than what one might expect.
So I want to get into the characterization of misstatement of law, but before we do that, with your permission, I'm curious if you have a sense for why the judge ultimately went in this direction.
I think judges are often wary of like, wow, we don't want to really mess up. There's often this implicit, deeply held assumption that the market is going to work, that it's going to figure things out, and us judges need to be constantly and persistently mindful of that. I also think that, like, Google very much played the AI card. That's really sort of changed people's perceptions of what is search, how do people access search, find information, etc. And I think Google leans into that really hard. It's very obvious as well that it's sort of the industrial policy of what the United States is doing, or what, whether it's with the Trump administration seeking investments in AI, like AI is be like the thing. And so it seems reasonable to say that Judge may have been aware of that, or really adopted Google's assumptions like this. Throughout the opinion, Judge Mehta seems like Google will do this, or Google has said they're going to do this.
But that's sort of what's baffling to me, because throughout most of the liability decision, there were discussions around evidence spoliation and creating some pretty significant trust and accountability issues for Google. I just wonder if the DOJ had this to do over again, might they have reminded the judge in their proposal for remedies that Google's credibility was seriously questioned? And by the way, not just the evidence spoliation, but there were examples, people within Google said, hey, we need to meet the next quarter's numbers. Let's tweak the algorithm and get advertisers to pay more and see if anybody notices. Like, there were clear examples what was abusive behavior. And it doesn't seem like any of that from the liability phase made it into the remedies phase. Am I missing something?
I don't want to say he wanted to tone down his liability decision, but it definitely seems like it's almost like implicit regret. At least that's what I get from reading it. But it's also hard for me to, I don't know Judge Mehta, I can't read his mind. But what comes out as you read the opinion is that if you're not understanding what the law is and what it requires you to do, that also has downstream effects. And for me, that as I read the opinion, he's not living up to the moment of what the law requires, but also he misstates the law. And again, that feeds into how the opinion goes. Or he outright in one instance, especially in a footnote, he almost says in basically no unclear terms, I'm just going to not follow what the law says.
I remember back in law school, one of the things that they would say is sort of like a little dirty little secret of how judges work through things is oftentimes they kind of have a gut feel of where something needs to land. And then they try to dot the I's and draw the path through the law to get to that decision. And it feels to me like that's what Judge Mehta may have done here. And that, look, I'm steeped in the digital media world. I've been doing it for 25 years. I've reached the point where the status quo is bad enough that it's better to just blow the whole darn thing up into smithereens and hope for the best. But I can understand how a judge who might be less steeped in how this stuff works and really how bad it is might be reluctant to do something that he interprets as blowing the whole thing up into smithereens.
I don't think judges want to be seen as destructors. They don't want to be seen as pulling the levers of power, pulling the levers of, quote unquote, the market. But it's a very flawed way of thinking, because they are, in a sense, the antitrust laws, fundamentally decide the coordination rights of businesses, the acceptable business practice of the market. So by ruling however which way, no matter what, you're setting the guardrails. It just depends on what direction they're bending toward. Judge Mehta, I just feel, again, as throughout the opinion, he just expresses, there's that phrase, humility and caution. And,
yeah.
Which he interprets as overriding all of the other requirements per Supreme Court controlling precedent that he's supposed to do. And again, I want to emphasize this. People seldom read, Supreme Court opinions. They're often wonky and use plenty of jargon and, concepts completely unfamiliar to the layperson. But the court actually speaks in very clear terms. There's a duty in one or an obligation, and one opinion says that judges have an inescapable responsibility to impose strong remedies. There's many cases where there's this one from this case, American Tobacco, which was basically decided at nearly the same time as the infamous Standard Oil opinion in 1911. And there the court uses, admittedly, a little floral language, but it really gets to the heart of what judges are supposed to do, which they say to remove the ingredients or to destroy the ingredients of a combination, and not just merely, stop the conduct, but actually engage in a restructuring to ensure that the conduct is stopped and can't happen again. That is the obligation of a judge to do that.
Well, okay, but with that in mind, can you walk through some of what you said, legal inconsistencies? Because that's something I'd really like to be able to dig down into. Like, can you give a couple of examples?
Yeah, so I guess it's a matter of opinion, but one of the strongest remedies that he didn't impose was that he barred Google from entering in purely exclusive agreements, right? And this is like the bare minimum, right? This is the heart, the essence of the entire case. Like, if the government couldn't get this, like, what was the point of liability to begin with? So, okay, great. But then Judge Mehta goes on to say, we're going to still allow Google to make payments or, quote unquote, offering other consideration to distribution partners for preloading or for the placement of Google Search, Chrome, Gen AI products. And why does he allow this? Again, what's odd is that he says it'll be, quote unquote, crippling to the downstream distribution partners. And he's mainly talking about, one of the partners he's talking about is clearly Apple. So, like, number one, Apple doesn't need billions from Google. They just said they're going to give $100 billion in stock buyback. So it's not like they even need this. But it also, where the contradiction comes in is this really seems like a back door to Google's conduct in the first place, right? And so they can't be exclusive, but Google has so much money to throw at it. You're basically creating a situation where Google just needs to write a bigger check. So it's not exclusive explicitly, but when you're making something as lucrative as Google can, again, because of their dominant position, you're really saying just Google needs to get to their position in a different way, which they're optimally positioned to get. Well,
exactly. The idea that of a non-exclusive distribution agreement where the default setting is going to be Google is a distinction without a difference. Once you've set the defaults, 99.9% of people are going to keep the defaults. So the distinction between saying, well, it's not exclusive because you can, in theory, move to somebody else is just not born in common sense. So we're outside of the law here.
Let's not forget, he admits this. He repeatedly says that one of the effects of these agreements, he says this both in the remedies opinion and in the liability opinion, that the purpose of these agreements is not just to shut out competition, and not just to or entrench Google's position. It is also for the data, for all of the and to get the access which actually makes the product. So if you are, by not actually affecting the method for this specific method, you're actually not doing anything to help the competitors from being shut out, because this is something, and this is one thing I think Judge Mehta just doesn't appreciate enough, is that the agreements didn't just entrench Google's position, right? That's one effect. But what they actually did in the other side of that same coin is they fundamentally blocked other competitors from being viable competitors, from actually getting there. So if you don't actually shut off that mechanism, you're really not aiding the marketplace for helping competition actually thrive, because you're not giving the kind of aid that's required for other competitors to actually be positioned to have a chance to fight against Google.
Yep. What's your take around, I think one of the justifications was, well, 80% of your audience for Chrome, or the user base for Chrome, is outside of the US. I was a little baffled by that as well, because I know for a fact that the EU Commission and to a certain extent the UK Competition and Markets Authority were literally waiting. And I'm sorry, Canada and to an extent Australia, all these places were waiting on this decision to build from it. They weren't waiting on the decision thinking, okay, yeah, then we'll just do what we need to do in our own little market. And so I was really surprised by that. Is there some precedent there that I'm missing that it can only cover the US?
Yeah, well, what's interesting is in antitrust law, there's this thing of like, when you define a relevant market, that the whole, which is, again, if you're a monopoly, the question is monopoly of what, right? So you need some reference point of actually saying, so that, and we know that the market was the United States. But so in that part of the opinion, what was baffling, I think what you just said, we're now moving away from considering the effects in the US market, saying, oh, but we have to consider everything else, even though that's not what we're talking about. And again, when you engage in that kind of analysis, I think you could almost say it's like a Hail Mary from Google. But what about all of our other operations? Forget that we violated the law, but think about all these other considerations for all these other parties. Like, it seems in a sense that Google wanted to, I don't want to say obfuscate, but at least I would say minimize the actual harms they did in the US relevant market, and say, but consider all these other factors. And so that's supposed to mitigate. And never mind the fact that, like Chrome, even though like it's because Judge Mehta laments about all the difficulties of separating Chrome, and it's its own product. It's, there was the Knight Georgetown Institute. They came out with a report.
Yeah, Alyssa Cooper and her friends, right?
Yes, that's right. You already know the report I'm talking about. They came out and just said, oh, this is totally technically feasible. Like, it just seems like in this lawsuit that his role, I would almost say he doesn't see his role of enacting change, maybe in the sense of that's not his job, or that he may not think that the harm that he found was unlawful is even that big of a deal, which again makes very, very little sense, especially when you put it in the context of the wording he used in his liability opinion.
So there was a very specific issue surrounded by a previous case called United Shoe that directly addressed the question around structural relief, because Judge clearly took the presumption that structural relief was only if emergency break glass for structural relief. I thought I read somewhere that you were kind of picking that apart a bit, and I would love it if you would do so here.
So yes, so that what a great question, because that this is definitely one of the most important points is the rules of structural remedies, or just remedies in general. So let's step back a very important point. The antitrust laws, there's Section 1 of the Sherman Act that bans restraints of trade, which it basically targets firms, more than one firm. Then you have Section 2 of the Sherman Act. It targets dominant firms against single firm conduct. You have Section 7 of the Clayton Act, which targets mergers. So we have all these different pathways to liability. And then each of those statutes has different standards of liability. What does a plaintiff need to show to actually get liable? What defenses are available? But here's the trick with antitrust law, is that they all lead to the same remedies provisions. There's 15 USC 25 for government enforcers and 15 USC 26 for private plaintiffs. And even though the language is slightly different, they've basically been interpreted that the courts have their full equitable authority behind to actually resolve the issue here. So now when you know that, okay, once you're liable, all of the remedies are available to you, right? Then you say, what does the case law say about how I'm supposed to think about remedies? And here the court has been clear to the case you cited, which is United Shoe. The court has been very clear, but not just in United Shoe. It's been clear repeatedly that structural relief needs to be at the forefront, needs to be considered first in how we think about remedies. And why? Because it's simple. It actually gets the courts out of involvement. Because if you think about a behavioral remedy, if you just say, don't do that, come back and check with us, you're leaving most of the, again, the court uses this word ingredients. I'll just use it here because I'll stick with the language that the court uses. You're basically leaving the ingredients that led to the unlawful conduct untouched. And then you have to come back to the court and waste the court's time. So when we think of structural relief, it's actually the court's preference doesn't just come from its ease of administratability. It is a requirement. It's sure, it's administrable. And again, with Judge Mehta's discussions, he almost seems like the cautiousness that I have to look at it. Then there's this whole discussion. Again, it's a little technical, but it's one of the most revealing aspects of his thinking. Is that it's in antitrust parlance, it's this causal connection idea, is the relationship between the liability and what kind of remedy is imposed. And in his mind, that structural remedies are the most extreme and sort of behavioral remedies are, sort of the easiest. And the more structure you go, the more connection that you need. And he uses what he calls a sliding scale approach, that the stronger the remedy, the more rigorous the relationship has to be. And again, this is contrary to what the Supreme Court has said. This case, National Society of Professional Engineers, and it says that all that's needed is it needs to be reasonable. He basically takes a made-up standard, has a distaste for structural remedies, even though the law requires him to actually use structural remedies. It's just not following, not being showing fidelity to the law.
So you've identified a couple of places where you think, and you've made a good argument for Judge Mehta being wrong on the law. And so my next question then is going to be, how do those types of inconsistencies play into any potential appeals process?
That's a great question. So there's a couple of things that I think are important here. So number one, so what would Google appeal? Let's just take each of the parties. Would Google appeal? There's actually a chance that they might, because they have an interest. So there's many of our nation's remedies scholars, when they describe remedies, they really describe remedies as the meat of substantive law, that without good remedies, the substance of your claims really doesn't mean much. So
we've seen that in spades over the last week.
Yes, right. So Google, even though, it's got a weak remedy, they actually might appeal. Maybe they feel emboldened, one, to attack the liability decision, right? That's always a chance. And again, when you go to appeal, now you're making law, right? Now when you're at a circuit court, now you're making law. But the other thing is maybe just if they won on basically almost every other remedy, right? They only have to basically not do one little thing, which by the way has a back door. They may feel emboldened enough, being like, yeah, we're going to take this up to get this codified because we're under attack and all these different lawsuits that are going at us. And we know that the DC circuit, is, for a variety of reasons, is, one of the most important circuit courts in the business. The Microsoft cases was cited ad nauseum. Like, this is another chance to reinforce the importance of that decision and make new precedent that says, leave Google alone. So they had a lot of incentives here to do that and get things hard, because they know they're under attack from different sides. I guess one of the most famous in the United States is the Epic Games case.
I would imagine they want as little oxygen pointing in their direction as a confirmed monopolist as they can, because that's just going to encourage more versions of Epic Games. And we've seen just in the last couple of weeks, slightly different things. I think these were a little bit more ad tech related, and that's a separate trial. But there's been a couple of suits launched over the last couple of weeks alleging that Google is a monopolist. So if Google can get rid of that moniker here, I think that would be helpful. Now, whether that's a realistic goal is certainly debatable. But then that gets you to the second area, which is like, what is the current DOJ's appetite for pursuing this, given that A, they've already sort of declared victory, and B, you now have the current administration seemingly backpedaling and walking away from this directly with Google CEO.
Yeah. So again, there's so much going on with the DOJ. It just seems to be there's a lot of lack of clarity. You have Assistant Attorney General Gil Slater, who desires to enforce the law, who desires to have a fidelity to what the law requires. She's given a number of speeches on that. And
I thought she was a great pick.
She's. If I recall correctly, she's President Trump's has the most one of the most bipartisan support. Like if you look at her Senate votes, it's like I think it was 73. Which is definitely one of the highest. I think only second to Secretary of State Marco Rubio. She clearly has an appetite for wanting to, but yeah, the administration, it's unclear what, there was the tech dinner yesterday. I don't know if you saw that. It was making the rounds on online, and President Trump said to Sundar Pichai, "So you had a big day yesterday, and the Biden administration litigated that case." And I don't know what that means. It's like, actually, President Trump, you brought that case under your first administration, and your own department. They didn't get the liability decision, but your DOJ litigated the remedies portion, right? So it's like you have a lot to claim here, and it just seems like you don't want it. So I don't know. So that to me leads to they may not appeal, but might use it as a bargaining chip of some kind. Say, hey, we know you won here. We could clearly see that you probably don't want to litigate this, or appeal this particular case. Let's settle. And that could happen. Now, again, the other thing is the DOJ might litigate because they might want to avoid a Tunney Act review. Because if the DOJ settles, now that opens up to Tunney Act review and public comment, which
walk my audience through that a bit.
It's basically a judicial check on antitrust settlements from the DOJ. And it was enacted in the wake of the Nixon administration because then there was some shady antitrust settlements, most famously involving ITT. I think it's International Telegraph and Telephone is the pulled apart acronym. It was obvious then that the antitrust settlements could be used as a sort of corruptive bargaining chip, as a cudgel. You have the weight of this law that can break up your company, and it's easy to use that as a means of corruption. There's been many documents throughout instances throughout history of presidents using the threat of antitrust enforcement as a sort of cudgel. So the Tunney Act basically says that if the DOJ is going to enter into a settlement, there is an opportunity for public comment. There's this thing called the competitive impact statement, which analyzes the settlement and sees its actual effect on the marketplace. And then a judge has to ensure that the settlement is, quote unquote, in the public interest. So a judge could, if they want, but
okay. And so you're positing that the likelihood of a settlement is a little less likely because of fear of a required review of that settlement under the Tunney Act.
Yeah, especially in the wake of the Juniper, the HPE, Hewlett Packard Enterprises Juniper deal with the whole with Roger Alford's firing / departure, his whole speech that he gave, rule of law versus rule of lobbyists. So especially in the wake of that, the DOJ might want to avoid a Tunney Act review. So they may be required to appeal.
It's funny, the forgotten actors in this dance are the blue states led by Colorado. And I'm curious if you have some thoughts regarding what the states may do. What is A.G. Weiser and his colleagues going to do? Because they've been pretty quiet. I've seen Gail Slater up speaking about this on a couple of pods, but I don't think I've seen anything from the states. And just curious if you have any thoughts there.
I agree with you. I think everybody's trying to play a little quiet here. I think everyone's sort of holding with bated breath, and it also makes sense. The federal government is seen, regardless of who's in power, they're often seen as the leaders on these types of things. But the states can, if they want, they can go solo. They did with the Microsoft case. Google really, because this is the first big monopolization case in a long time. from the DOJ, especially one is enforced with as much vigor, as it has as much public interest behind it. And this is like, you could almost think of it like this is the first domino in all of the other cases. So if you get this one right, this could help, spur confidence to litigate harder, to be more creative, to infuse some, much needed, confidence boosting. But if you lose, right, and because this case is so big, right, even Judge Mehta, in his opinion, talks about how many documents, how long this process has been. They did that. It also states the states clearly have a hunger for antitrust enforcement. They've shown, whether it's at using their state law with the Kroger-Albertsons merger, even with one even before that was it was the T-Mobile Sprint. Again, I think the next couple of weeks, because I forget when Judge Boasberg's opinion is supposed to come out, definitely very soon. That's really when we're going to see, I think there's going to be a lot more activity as terms of like decisions being made.
Do you have any sense at this point, or is it too early to even think about how this ultimately is going to play out? Not just the Chrome divestment, but the search index and AI index, enabling that to be combined is just a huge problem. And I've seen the quote, like, it's like die a quick death by giving up the traffic, or die a slow death by having them turn all of your good content into AI slop and not being able to monetize it. And so I'm really looking at that constituency, the ad tech, ad tech companies, digital publishers, to a certain extent, advertisers. Like, how does this play out?
So in that sense, they're complementary. So it almost seems prudent to wait. And once you say, okay, how best can we take this decision? And now that we got decisions addressing both sides of Google's business as they are as a company, then they can move forward for that. That to me seems like the most prudent way to go forward.
Well, that certainly makes sense. I've got one other set of questions for you. I mean, this is really within the ad space. This is something that's already starting to be debated, and mostly debated by business types who are probably less versed in this kinds of stuff. But there's a technical committee who is going to oversee a number of things, including the potential sharing of search data with qualified competitors, whatever in the world that ultimately means. But walk my audience through, what is a technical committee? How does it work? And then maybe you can help me understand, how does Google not game this and run the whole thing around in circles for the next several years?
Right. So this is a great question. So the technical committee is basically going to be a group of people that administer, as agents of the court, to determine how to actually hold Google accountable to adhering to the actual remedies provision. So I'll give a good example of that. So in the opinion, Judge Mehta says, even though he struck down the anti-circumvention and anti-retaliation provisions, he has a line in there about saying, well, I'll be open to modify this order as circumstances depend. Well, how do you know what circumstances? The technical committee will inform the court that Google's either not complying or they're not adhering themselves to what was actually ordered. Now, I think the technical committee can be gamed in a sense. They can also be running in circles, but I don't want to undermine the importance of a technical committee. I think the most relevant example here, the United States v. Apple decision from 2015 out of the Second Circuit in New York City. And for those unfamiliar with that case, it's more colloquially known as the ebooks price fixing case. And Google, in there, Apple was found liable for organizing what's called a hub and spoke price fixing conspiracy, where Apple fixed the prices of ebooks by convincing all of the publishers to adhere to their terms only if other book publishers would join in. And there was a technical committee, and Christopher Sagers has a great book giving all the details. It's literally called United States v. Apple. And that gives all the details about that, about the opinion, about what happened after the lawsuit. And there he describes in detail just how much of a headache. They call it, the term is special master. Again, very similar roles. Agent of the court overseeing the adherence to the court's orders. And in there are internal emails. There's communications from Apple executives just complaining constantly about the special master's interference, the number of document requests, the threat of telling the court that they're not listening. So I don't want to say a technical committee is like seen as a weak thing, because you are quite literally putting the court or an agent of the court into the business, right? You are saying that now you have oversight over what you are doing. So yeah, that's what I think will happen. Now again, Google could flood them with data, but I think Google has an incentive to comply here. They know they've won on so many grounds, and they know they're also in the background. Even though Judge Mehta doesn't express it in his opinion, he does know that, with the whole suppression of evidence, they already end up looking at it in a bad light. That's not good. That's just like, practically grounds for, disbarment for the attorneys, sanctions on Google. Like, they already know they're under a light, and they know that since they mostly won, they avoided a divestiture, they actually may not want to yank the chain, so to speak, of the technical committee to the extent that they do. They may just say, you know what? If anything, it's in their best interest to comply, or at least be generally pretty nice, because they don't want to have to go back to the court and say, it's almost like a 3 strikes you're out. So you messed with us on the evidence. Now you're not listening to the technical committee. Now we're going to put the hammer really down this time. Like they don't want to do that.
So I just want to jump in real quick, because I feel like a technical committee works significantly better with an Apple. Apple is to Bill Belichick as Google is to Ted Lasso. So so with Bill Belichick, when he does something and sticks his middle finger up at you, the technical committee goes, hey, look, here's a picture of him sticking his middle finger up at us. Like, the judge goes, okay, man, listen, you got 2 more chances. With Google, they're so good at this, and they're going to come back and say, well, there's privacy reasons that we can't turn over data. And, we're not going to give it over to our best competitors. And so, and they'll continue to refine the process, and invent reasons why that's beneficial to everybody in ways that are very difficult. Even if you understand in a lot of detail, it's difficult to disprove that. And that's sort of where I have a problem with the concept of relying too much on the technical committee. And one of the reasons I was much, much more hopeful that divestment would be an option.
Yeah, I agree. Listen, I'm trying to be an optimist, right? Maybe that's why I'm in the advocacy role that I'm in, is right, because I'm going to be a perpetual optimist. If I was a doom and gloom, I'd probably be. I have to get out of I have to find something else to do with my life. You're completely right that a technical committee is not sufficient at all. I would have loved a structural remedy. My interpretation of the law is he was required to put a structural remedy there. But I'm going to take any victory I can and say that this can do something. And again, this is really the lesson of Microsoft, right? Like, this is why I think a structural remedy was so important here, is that the lesson of Microsoft was, if you don't do a structural remedy, nothing is going to change. And during the Microsoft litigation, there was a state report, and it was led by California, and it was submitted to the court, and they basically just slammed the court, saying this consent decree is not working. Microsoft is still dominant today as they were when the lawsuit started, because the Microsoft consent decree there only did behavioral remedies, slap on the wrist, some sharing of code. Judge Mehta clearly didn't rise to the moment and didn't adhere to the law here, and it could cause the government to come back. But again, this is why I think, to say it again, it's so important. It's going to be very important to wait for the ad tech ruling, and then we can actually see all of the cards. Like, again, because so many different aspects of Google's business model is under scrutiny at the same time, right? It's important to get the whole picture before I can fully say, oh wow, like this really just is a bad situation. Yeah, again, the opinion is embarrassing for a lot of reasons, as I described, but I'm hopeful that the ad tech decision will also bring more light and be a little bit better, and then we'll have really all the cards to see on what can happen next.
Okay, well, this has been a fantastic discussion, Daniel. I got one more question for you. This should be a real easy one. You're from Connecticut. I'm from Connecticut. We both went to the University of Connecticut. What is the combined record of the women's and men's basketball team going to be in this upcoming year?
Oh my goodness! Oh goodness! I have no idea. That's a tough one.
You disappoint me, my friend.
Here's the thing. My tenure at UConn extended from 2008 to 2012 as an undergrad, and then from 2016 to 2019 in law school. And that's really like the height of the UConn dynasty, right? Of like complete, especially for the women, complete shutout years, breaking records and consecutive victories. So like, I am like permanently scarred from all the emotional highs of that time period. And so my frame of reference is that's how they're always going to be forever to me, as just pure dominance. I don't know. It's a good question. I wish I had a crystal ball.
You kids got spoiled. When I was there, man, when I was there, I think we won 9 games one year. We did win the NIT, and like that was like the top of the mountain for us. But the right answer, and I'm a little disappointed in you, I got to be honest with you. The right answer is undefeated.
Right, undefeated. I hope every year to see the undefeatedness. I do. I every time I hear about it, it's I've actually checked like internet search trends on UConn and University of Connecticut, always around basketball season, and you just see it. It literally every time. It's literally like clockwork, which I love to see because I take an immense amount of pride going to the University of Connecticut, both as an undergrad and as a law student.
Me too. Well, we're going to leave it there, but this has been a fantastic discussion, Daniel. Daniel Hanley, I really appreciate you coming on. Hopefully we have you back on.
Thank you so much. Appreciate it.
That was a great discussion. I really appreciated Daniel's perspective on all this. And I understand that there's still a lot of dust that needs to settle around this decision. But as of right now, I just don't believe there's much to be optimistic about here. First, and I think this borne itself out in our discussion, I think that Judge Mehta's remedies decision here is too weak to enact meaningful change. Second, it doesn't seem like the DOJ is going to continue pushing up this hill. They seem poised to declare victory and move on. Third, the European Union appears to have blinked once the Trump administration started showing its teeth. And it seems like their talk of requiring or at least requesting a breakup of Google has gone by the wayside. Similarly, the UK Competition and Markets Authority has all but announced that it's dropping its case against Chrome and the Privacy Sandbox. Finally, I don't think the remedies in the DOJ is even looking for in the separate Google ad tech case is likely to have a material impact on the digital media marketplace. So with all that, I'm struggling to find a silver lining in all this, or even a bit of light. As of today, the only additional potential avenues that seem to be private antitrust litigation or the U.S. Congress reforming antitrust law significantly. For the short term, I think the best we're going to get here are congressional hearings. So I really try to be an optimist, but I just don't see much out there right now to support an optimistic view. Meanwhile, I'll continue to bring on really smart people on this podcast to discuss thorny issues here in the ad space, hoping that together we can come up with some solutions. To that end, we've got a bunch of other fantastic guests coming up on the Monopoly Report podcast. In a few weeks, I'll have the author, Patrick McGee, and he'll be on to talk about his book, Apple in China. And soon I'll also be speaking with the former FTC chairman, John Leibowitz, where we'll be talking about some of the antitrust decisions made regarding Google back in 2012 and 2013. We'll also be talking about the do not track standards. So that should be a really fun discussion for all the policy nerds out there. Both of those are going to be great discussions. So please subscribe to the show at monopolyreportpod.com or on Spotify, Apple, YouTube, or wherever you listen to your podcasts. And thanks for listening.
Thank you for listening to the Marketecture Podcast. New episodes come out every Friday, and an insightful vendor interview is published each Monday. You can subscribe to our library of hundreds of executive interviews at marketecture.tv. You can also sign up for free for our weekly newsletter with my original strategic insights on the week's news at news.marketecture.tv. And if you're feeling social, we operate a vibrant Slack community that you can apply to join at adtechgod.com.